Hello, everyone. Good morning. I'm Colleen McLaughlin, the Associate Director of the Boggs Center on Developmental Disabilities, part of Rutgers Robert Wood Johnson Medical School. And I'd like to welcome you to the 292nd session of the Developmental Disabilities Lecture Series. Today, in this fall, we thank you for joining us virtually. The lecture series is a semi-annual continuing education activity of the Boggs Center, New Jersey's federally designated University Center for Excellence in Developmental Disabilities and Leadership Education and Neurodevelopmental Disabilities program. We gratefully acknowledge support for this series, which comes from the New Jersey Division of Developmental Disabilities and the Administration on Intellectual and Developmental Disabilities in the U.S. Department of Health and Human Services. The Boggs Center is committed to supporting the developmental disabilities community in New Jersey as we continue to face the coronavirus pandemic. We want to remind you that we have a plethora of COVID-19 related resources that you'll be able to find on the Boggs Center website. These include information about just basic general information that's accessible to people with developmental disabilities, information on mental health, self-care support, employment, planning for emergencies, and so on and so forth. All of these resources are available in English, and many are also available in Spanish. Before I introduce our presenter, Barry Whatley, I want to share a few details about the webinar format of this session. First, you'll see all the slides on your screen during the webinar presentation. The handouts can also be downloaded. If you'd like to download the slides and handouts, please go to the handout section of the control panel on the right side of your screen. The handouts will also be posted on the Boggs Center website next week with a webinar recording. We're planning to have a brief question and answer session at the end of this lecture. In order to ask a question, you have to type it into the questions section of your control panel. All of the attendees are muted and will not be able to ask questions verbally. We encourage you to type in your questions during the lecture and not wait till the end. We'll compile them and try to raise as many questions as we can following the presentation. We're pleased that we're able to offer continuing education credits for this webinar. To receive a certificate of attendance for continuing education recognition, you must be logged on to the webinar from start until finish and complete the evaluation at the end of the webinar. Certificates will be emailed to attendees who meet these requirements at the end of next week. So 30 years ago, the Americans with Disabilities Act became a law, a milestone in the disability rights movement. The ADA prohibits discrimination against people with disabilities in all areas of public life, including employment. Title I of the ADA was designed to help people with disabilities access the same employment opportunities and benefits as those without disabilities, and requires employers to provide reasonable accommodations to enable applicants and employees with disabilities to perform their jobs. We are fortunate to have Barry Whatley with us today to commemorate the 30th anniversary of the ADA and explore provisions that address long-standing gaps in the workforce participation of people with disabilities. Barry Whatley works at the Burton Blatt Institute at Syracuse University's College of Law. He is the project director of the Southeast ADA Center, the principal co-collaborator with the University of Leeds in the United Kingdom's Inclusive Public Spaces Project, co-collaborator with the University of Queensland, Gender, Equity, Disability, and Social Inclusion Mainstreaming Short Course, and the principal investigator of the Mid-Atlantic Youth and Self-Advocacy Project. Previously, Barry was the project director of the Supported Higher Education Project at the University of Kentucky Human Development Institute. For many years, he was the executive director of Community Employment Incorporated, a supported employment provider. Mr. Whatley is an alumna of Indiana University and earned his master's degree in mediation, arbitration, and conflict management from Sullivan University. A heartfelt DD Lecture Series virtual welcome to Barry Whatley, who will present to us today, the Americans with Disabilities Act, Disclosure and Reasonable Accommodations in Employment. Here you go, Barry. Thank you for joining us.
Thank you so much. Let me make sure my webcam comes on. There it is. Hey, everybody. Yeah, so I get to do all that. I work in Leeds, I work in Australia, and I never even have to leave my bedroom. It's the best of all worlds. So again, thank you for having me today. My name is Barry Whaley, and as Colleen said, I work at the Burton Blatt Institute at Syracuse University College of Law. We are a disability law and policy center. Our mission is to advance the economic, social, and civic participation of people with disabilities around the world. So again, I'm very happy to be with you all today and to talk about the ADA. So there are two things we're going to cover today. We're going to talk a little bit about disability rights history and then center on the employment provisions of Title I. As a quick disclaimer, I am funded by NIDLR, the National Institute on Disability, Independent Living and Rehabilitation Research. I am not offering you any legal opinion today. I am only offering you informal guidance on the Americans with Disabilities Act. So let's start with why this is important. And here is a quote that I want to share with you. How can we know who we are and where we're going if we don't know anything about where we have come from, what we've been through, the courage shown, the cost paid to be where we are today? That's from David McCullough from his book, Brave Companions, Portraits in History. Let's begin with a disability rights timeline, because some of this is just very interesting and really kind of sets the stage for our conversation today. So we begin in 1917 with the Smith-Hughes Vocational Rehabilitation Act. Smith-Hughes, as you can guess, by the year 1917, was the first vocational rehabilitation act for returning World War I veterans who had who had experienced disability as the result of combat. In 1920, we have the Fess-Smith Vocational Rehabilitation Act. Fess-Smith was the first civilian vocational rehabilitation act. 1933, we have the first president with an obvious disability, Franklin Roosevelt, a very important milestone. And I have a book recommendation for you. The book is called FDR's Splendid Deception. It's by a guy named Hugh Gallagher. And the book, it's just a fascinating book at the lengths to which Franklin Roosevelt and other people, including his son Elliot, went to hide the obvious disability from the public for fear of how he would be perceived. 1935, we have the League of the Physically Handicapped, which was formed. Interestingly, the League of the Physically Handicapped is formed because, as you recall, we're in the midst of the Great Depression, right? Franklin Roosevelt begins the New Deal to try to pull us out of the economic depression. The National Recovery Act, the New Deal, did not, in any of those employment programs, hire people with physical disabilities. Hence the need for that organization to be formed. So what an interesting thing to think about is the first president with an obvious disability puts a program in place that doesn't hire people with disabilities. 1938, we see the Fair Labor Standards Act enacted. A lot of good things come from the Fair Labor Standards Act. The 40-hour work week is institutionalized. Child labor is eliminated. But then we have in the Fair Labor Standards Act that odd provision 14C. 14C says that somebody with a disability can be paid a sub-minimum wage. The belief at that time was that in doing so, it would encourage employment of people with disabilities, when in fact, we know today all it has done is discourage people with disabilities from getting real, meaningful, competitive, integrated jobs. In 1940, the American Federation of the Physically Handicapped is formed. 1946, we have the National Mental Health Foundation that we know today as NAMI. And I failed to mention, I'm sorry, the American Federation of the Physically Handicapped is known today as AAPD. 1951, We see a small obscure camp, Camp Jened in the Catskills of New York begins. And Camp Jened becomes important because it becomes the epicenter of the disability rights movement in the late 1960s. So my first movie recommendation for you, if anybody out there, and I can't imagine there are many who have not seen Crip Camp, please do so. It is just a fascinating narrative of the modern disability rights movement. So moving on to 1964, we have the Civil Rights Act. And the Civil Rights Act includes provisions for equality based on race, based on ethnicity, but one area in particular that is overlooked in the Civil Rights Act, our largest minority, people with disabilities, are not included in the Civil Rights Act of 1964. 1972, we see a couple of court cases of interest, Mills versus the DC Board of Education and Park versus Pennsylvania. These cases had nothing to do with what type of instruction students with disabilities in public school programs would receive, but whether if children with disabilities should even be in the classroom at all. 1973, we see the Rehabilitation Act. 1975, the Education for All Handicapped Children's Act that we know today as IDEA begins. 1978, the ADAPT bus protests to make public transportation accessible to all people, especially people with physical disabilities. 1986, the Air Carriers Access Act is enacted, which allows for equal opportunity in air travel. 1988, we see I. King Jordan become the first deaf president of Gallaudet University. So Gallaudet was formed in the 1860s. It took over 130 years for Gallaudet to have its first deaf president. Probably the single greatest example of ableism, that it took that long to have the first deaf president at Gallaudet. 1990, the Americans with Disabilities Act, which is our focus for today. And then in 1999, Olmstead versus LC, where the Supreme Court reaffirmed that reaffirmed that Title II of the ADA, as well as the 14th Amendment, applied that people should be able to live in the least restrictive environment possible. So let's talk for a few minutes about the Rehab Act, because the Rehab Act is the foundational law for the Americans with Disabilities Act. Passed into law in 1972, but it was originally vetoed, as we know, by Richard Nixon, who thought it too costly and unenforceable. As I said, it became the foundation of the ADA in 1990. There are a couple of sections that we need to be aware of in the Rehab Act. 501, which prohibits employment discrimination based upon disability in federal government hiring. Section 503 that prohibits discrimination in employment by federal contractors and subcontractors. And presuming you are a supported employment professional, you are aware that Section 503 includes the provision of the aspirational goal that 7% of the workforce of federal contractors and subcontractors will be composed by people people with disabilities. We have Section 504, which prohibits discrimination on the basis of disability of programs receiving federal funds, which led to, in 1978, probably the watershed moment of the disability rights movement, the occupation of several federal buildings, most in particular the San Francisco Federal Building, by people with disabilities, because Joseph Califano would not implement Section 504 of the Rehabilitation Act. So there are a couple other amendments I want to bring to your attention. In 1978, Centers for Independent Living were instituted as part of the Rehab Act, and funding was provided for them. And you know, we could talk at another time about Ed Roberts and the SIL at Berkeley and the start of the independent living movement. 1986, supported employment becomes a outcome under the vocational rehabilitation program that would lead to people with the most significant disabilities in getting a job. And then in 1992, employment becomes the primary goal of vocational rehabilitation. So, what is the ADA? Well, the ADA is civil rights law. It is not preferential treatment. It is equality of opportunity for people with disabilities. As George Bush mentioned at the signing of the ADA, let the shameful wall of exclusion finally come tumbling down. So we see a number of people here in particular. We see Justin Dart in his cowboy hat to Bush's left, and we're going to talk a little bit more about Dart in a few minutes. Interestingly enough, the Sandra Perino is also in that picture, Ed Kemp of the EEOC, and then the priest who is behind Mr. Kemp. And the priest in this situation was someone who was born without arms, and as we know, it's customary at the signing of major law that the president will give away pens, you know, that he used to sign the law into place. And in this case, he had to accept his pen with his foot, possibly one of the greatest moments in disability rights history. Here's a hero of mine, Senator Tom Harkin. Senator Harkin he was the chief sponsor in the Senate of the ADA, and he refers to the ADA as the Emancipation Proclamation for people with disabilities. And Senator Harkin also said, disabled individuals spend a lifetime overcoming not what God has wrought, but what man has imposed by law and custom. Senator Harkin, when he gave his speech on the floor of the Senate in support of the ADA, gave it in both English as well as American Sign Language. His brother Frank was deaf as the result of meningitis, and so part of Senator Harkin's passion for the ADA comes from his love for his brother. So I want to ask you a question, and we'll have a poll that will come up here. I'm curious, how many people with disabilities do you believe there are in the United States? Can we have the poll, please? There we go. 31 million, 41 million, 51, or 61 million people. Go ahead and select your answer. Can we see our results? Do we have the results? There we go. The majority of you, slightly, say 61 million. 36% of you. 35% said 51, 20% said 41, and 8% said 31. Well, as you can imagine, because there is not great consensus here, this is really a difficult question to answer because disability is defined in many different ways. How VR defines disability is different than how the ADA defines disability or how Social Security defines disability. And then if any of you are veterans, we know that the veteran definition of disability is based on a percentage of impairment. So very, very difficult to pin this down, but if we could take the poll away, please, we can move on. Thank you. Oops, there we go. There are 61 million people, according to the Center for Disease Control and Prevention. So, and I feel that this is a pretty durable number. I've seen numbers as high as 92 million based upon definition of disability. But if we look at 61 million, I'm pretty confident about that because we're using here a social definition of disability, which says a significant impairment that affects one or more major life areas. So let me ask you this. Here's our second question. What percentage of people do you believe in New Jersey live with a disability? We could have that poll up, please. Thank you. Give you a minute to vote. The percentage of people with disabilities in New Jersey. Okay, can we see our poll results? 30%. We have 30%. 33% of you say 30%. 34% say 28%. 22% of you say 25%, and 11% are saying 21%. So if we could remove the poll, please. Thank you. According to best estimates, 25%, so 24.6% of residents of New Jersey have some type of disability. And New Jersey does a little bit better, or it has lower statistic than overall, where we're looking at 25.6% of people in the US who have disability. So, you know, we know that disability can occur one of two ways. It is either acquired or you are born with it. We are an aging population as well. So the likelihood of acquiring disability later in life is increased proportionally. So let's spend some time talking about the ADA and what it is and what it isn't. As I mentioned before, it is landmark civil rights legislation that guarantees equal treatment for people with disabilities or people who have an association or relationship with somebody who has a disability. So again, this is not preferential treatment. This is civil rights law that guarantees equality. And I want to just briefly mention, this is the 30th anniversary, as Colleen mentioned before, of the ADA. And we urge you on a social media platform of your choice, if you use the hashtag thanks to the ADA, and tell us why you're thankful for the ADA or how the ADA has improved your life. We would be very happy to learn those stories. A couple other resources for you: the ADA Anniversary Toolkit at adaanniversary.org includes a lot of material on the ADA that you can use not only on the anniversary of the ADA, July 26th, but throughout the year. So, what does the ADA cover? There are 5 titles to the ADA, and when we think about where the general public typically sees the ADA in action, it's typically Title III, the places of public accommodation and commercial facilities. So you might see it in a public restroom where there's an accessible stall, or an accessible parking place outside of ShopRite or Kroger. You might see it in crosswalks. You know, that's where the general public usually sees the ADA in action. But in fact, as I said, there are 5 titles. The first are the employment protections that we're going to focus on for the rest of our morning together. Title 2 are state and local government, so public entities and transportation. I've already mentioned public accommodation and commercial facilities, so those are banks, restaurants, shops, stores, anywhere where people go to access goods and services. Title 4 of the ADA has to do with telecommunications. This is probably the title of the law that has not aged as well as other sections, simply because, who could have imagined 30 years ago we'd be walking around with computers in our pockets, right? Then finally, Title 5 are the technical provisions. Who has enforcement, for instance, of the ADA? So why is it important to talk about Title I? Here is the most recent employment statistics from August 2020 from ODEP, the Office of Disability Employment Policy, Department of Labor. We're looking first at the unemployment rate. The unemployment rate currently for people with disabilities is 13.2%. For people without disabilities, it's 8.4%. So we've seen that the pandemic has had a tremendous impact on unemployment, right? People without disabilities was as high as 14%. People with disabilities as high as almost 17%. But unemployment rate only tells half the story, right? We also have to look at workforce participation or labor force participation. When we look at that, people without disabilities, 67% of people without disabilities are in the workforce. 20.6% of people with disabilities are in the workforce. So, what does that mean? 79.4% of people with disabilities are on the economic sidelines. They're not even looking for work. They are not part of the employment conversation. So what does ADA Title I say? Well, at its most fundamental level, it says that employers cannot discriminate against people who have disabilities in regard to any employment practice, term, or condition of employment, or the privilege of employment. So this prohibition covers all aspects of the employment process. Someone might need accommodation in order to complete pre-interview paperwork, or they may need help in the interview. If someone has perhaps intellectual disability and they need to have questions reframed in an understandable way. So the protections of the ADA begin long before you ever begin employment, at the very beginning of the employment process. And we will outline what that is in a few minutes. Excuse me. So not everybody is covered by the ADA. Private employers that have fewer than 15 employees, so 14 or less, you do not have to comply with the Americans with Disabilities Act. Interestingly, the federal government, not all aspects of the federal government, although ADA does apply to Congress, it does not apply to the executive branch of government because the ADA, or because the federal government is covered under the Rehabilitation Act of 1973. Corporations that are fully owned by the U.S. government, the FDIC, the Corporation for Public Broadcasting, those corporations that are owned by the U.S. government do not have to comply with ADA. Private membership clubs do not. And private membership clubs, we look at the exclusivity of membership in determining whether or not they fall in this category. So generally groups like the Kiwanis Club or the Rotary or those civic groups are not private membership clubs. Now the real exclusive country club around the corner from my house that I could never afford to become a member of, that has a pretty exclusive membership criteria, and under that scenario they would be exempt from ADA. The U.S. government executive agencies, as I mentioned, the Indian nations, the 514, I think, Indian nations do not have to comply with the Americans with Disabilities Act. And then finally, if you are a business that operates in a foreign country, if compliance with ADA would violate some foreign law, then you would not have to comply with ADA. So we're going to talk for a second about a qualified applicant. An employer can't discriminate against a qualified applicant or employees on the basis of disability. So there are three key phrases here that we need to break down. A qualified applicant, who is that? So qualified has two different meanings. Qualified in one sense would mean that you have a significant disability that impacts one or more major life areas. Qualified applicant also means that you have the skill, the experience, the education, the training in order to perform the essential functions of a job. So if you cannot perform the essential functions of a job, you may not have protection under Title I of the ADA. So the other two terms here is that you can perform the essential functions of the job with or without a reasonable accommodation. So, you know, it's right there on the application. When we help somebody fill something out to, you know, an application to get a job, it says right there, can you perform the essential functions of the job with or without reasonable accommodation? So what is a reasonable accommodation? Anytime we change a work environment that results in an equal employment opportunity for somebody with a disability, we have made a reasonable accommodation. Now, a business can only make a reasonable accommodation to a known physical or mental limitation that somebody has. I've known a lot of employers in the years that I have been doing this work. I have never met one employer who's a mind reader. So in order to get a reasonable accommodation, you have to disclose your disability in order to get that accommodation. So here are some examples. This is certainly not an exhaustive list, but screen reader technology would be a reasonable accommodation. I had a brother in my family. We have a history of macular degeneration, pattern dystrophy, and in my generation, my brother Dave, who died a few years ago, got ended up with macular degeneration. He was able to continue working in the later years of his life with the use of screen reader technology. Changes in schedules, reasonable accommodation. I have an employee, and she has said that I could tell her story. She has psychiatric disability, and she takes some pretty significant psychotropic medications in the morning. And so she's not really very good at 9 a.m. So an accommodation we have made for her is she begins work at 10 a.m. or 10:30. Now, does that mean that she gets to leave at 5 o'clock when the rest of us leave? No. So we have adjusted her time. If she begins at 10 a.m., then she leaves at 6 or 10:30, 6:30. So we don't change the function of the job. We just adjust her schedule in such a way that she has equal opportunity to do her job. Changes in break times. You know, I used to work with somebody who had lupus, and she needed to have additional break times, and they were afforded to her. You know, here's the universal accommodation for all of us in the current COVID environment, is working from home. And really, it will be interesting to see over the next several years, since we have learned that we don't need a physical office space necessarily to do our jobs, if you know how customary work from home will continue to be. Other job aids are reasonable accommodations. Changes in work location or work environment could be a reasonable accommodation. Some piece of equipment that could help you do your job better. would be reasonable. Elimination or exchange of marginal job tasks. So, and we will talk a little bit more about this in a second, but there are essential job functions, which are the reasons why the job exists, and then there are marginal job functions. So we only have to accommodate, in this scenario, the essential functions of the job. Marginal functions can be reassigned, they can go away. They are not essential to the function of the job. The last two here are probably the most controversial. Reassignment to another position or extended leave. Some courts have ruled, some circuit courts have ruled that if you need extended time off work, then are you really still qualified? Remember that issue of being a qualified employee. Are you still qualified to do that job? Overarchingly, the EEOC, the Equal Employment Opportunity Commission, has said reassignment and leave are okay, but they are accommodations of last resort. So as I mentioned, essential job functions. It's the reason why the job exists. And only a few people can perform those functions, and those functions are specialized. So I am qualified to do it because I have been trained, or I have the skill, the education, the knowledge in order to perform those essential job functions. A couple of things to remind you of, and first and foremost, I'm presuming some of you are employment professionals listening to me today. Your presence on the job, you are an essential, you are a reasonable accommodation. Your presence makes you a reasonable accommodation, because that is something that is necessary in order for that person to equally perform their job. A couple of other things to mention. The presence of a disability doesn't necessarily result in presumptive reasonable accommodation. What I mean by that is, there's obvious disability and invisible disability, and certainly obvious disability is pretty understandable, and the employer should be able to act on that. But what if you don't have an obvious disability? I was working with a family who, a lady who lives in Chicago, her brother was working at a big box store in Louisville, and he had a spotless employment record. And then all of a sudden, as we know, management changes and different people come in, and all of a sudden, this guy required paratransit service. And so we all know that doesn't necessarily run on time, right? And so allowances were made, accommodations were made. If he was a little late, that was okay. It was not translated to the new management staff. The guy ends up getting a bunch of write-ups, getting ready to be fired, and the sister says, don't they know he has a disability? Why are they doing that? So I had to ask, did he ever did he ever ask for reasonable accommodation? Did he disclose his disability? There was no record of it. He had originally gotten the job from a school program, a transition program, and it was just presumed that those accommodations were made. And make sure, so the cautionary tale here is in seeking reasonable accommodation, that there is a record of that conversation. And we'll talk more about that in a second. So a person with disability has the responsibility to disclose the need for accommodation. Accommodation should be reviewed periodically, because what worked in 2017 may not work in 2019 or 2022. Employers may ask for documentation of a continuing disability, and this gets into an area where employers will often feel that they need to protect themselves and will ask for every bit of medical documentation necessary. They're not, they are not required to get all that information. The only information of documentation of disability that they are allowed or should have is that documentation that speaks directly to that disability that is causing somebody to have trouble on the job and the need for accommodation. Somebody may have 2 or 3 different disabilities, right? But only one of those disabilities is resulting in difficulty on the job. So who has rights under the ADA? There are 3 prongs of disability determination. The first is you have to have a disability, or you have a record of having a disability, or you're regarded as. So let's break each of these down. So what is a disability? As I mentioned earlier, it is a physical or mental impairment that substantially limits one or more major life areas. So that is having a disability. That is the first prong of disability determination. And I need to note here, and when we get to it, that when we talk about regarded as, there's no need for accommodation under that scenario. As I mentioned, many disabilities are non-obvious. The number one disabling condition in the United States is arthritis. Intellectual disability is invisible or non-obvious. Having HIV or AIDS is, having a seizure disorder. So not recognizing that can lead to greater stigmatization. Going back to that my statement of where does the general public typically see the ADA in action? Let's assume you're walking into ShopRite, okay, and you see somebody pull into an accessible parking spot, and they get out of the car and they start walking into the grocery, right? The general public or others may say, hey, that person doesn't have a disability. They're scamming the system, right? Not considering that person may have a non-obvious disability that in fact does impact their life in a significant way. The ADA, as I mentioned, was passed in 1990. Over a period of time from 1990 into the early and mid 2000s, what we saw was a narrowing of the definition of disability by the Supreme Court, to the point where people were spending far too much energy trying to prove they had a disability rather than they faced alleged discrimination. So in 2008, signed by George W. Bush, we see the ADA, the ADAAA passed, which restored the definition of disability. What Congress said in passing the ADAAA is that we expect a broad interpretation of disability and a broad interpretation of mitigating measures or episodic conditions. And they also broadened regarded as having a disability. So, and I apologize because I mentioned having a disability. You could have a record of having a disability. So what do I mean there? Let's say that you are a cancer survivor, your cancer is in remission. So you are not actively involved with that right now. Or let's say, going back to my friend who had lupus, we know that lupus is a cyclical thing. There are some months or years where you feel pretty good, and then others where you don't. So if I have a record of having that disability, I may have protection under the ADA as well. And then finally, you could be regarded as having a disability, and I need to explain that. Let's say that you were in a car crash, for instance, and you have some sort of disfigurement. You don't have a disability that impacts a major life area, yet you go in, apply for a job, and you believe that you face discrimination because of your appearance, and that employer refused to hire you. Then you may have protection under the ADA. Now, as I mentioned on an earlier slide, if you're regarded as having a disability, you are not eligible for reasonable accommodation on the job. So often people mistakenly believe that the ADA only applies to full-time employees. No. Here are the people who have rights under ADA. Pre-employed people, as I mentioned before, full-time employees, part-time employees have protection under the ADA, seasonal workers as well have protection under the ADA, and temp workers. If somebody comes from a temp service, then they still have protection under the ADA. Now that begins to cloud who is responsible if there's an accommodation that requires some sort of cost. Is it the temp agency? Is it the host employer? The courts have ruled that generally, both equally share responsibility for those costs. This is interesting. So there is an association provision to the ADA as well. So I may not have a disability, but I have a known relationship or an association with somebody who has a disability. And I believe that I have faced discrimination because of that known association. Then I would have rights under the association provision. I would have rights under the ADA. So maybe my employer learns that I have a friendship or a family member with somebody who has HIV, for instance, and they perceive erroneously that I'm a threat. And so they take some sort of discriminatory action against me. Then I would have protection under the association provision. So again, it doesn't have to be a family member. I could be a friend, or I could just have some other association. Maybe it's even more of a professional association as well. So let's spend a few minutes talking about disclosure, because as I mentioned before, employers are not mind readers. They can only act on a disclosure of disability. So, and this is something very important, especially if you're an employment professional, that you should understand. So you never have to disclose a disability unless you're seeking a reasonable accommodation. I have known many people who have a disability that affects one or more major life areas who have worked their entire working life and have never disclosed disability. Now, here's an interesting situation where somebody has worked many years without disclosing disability, and then that disability is a progressive disability, and perhaps at some point they go to the employer then and say, hey, I'm having trouble doing my job, I need an accommodation, okay? The employer then could not take an adverse employment action against me. They couldn't say, hey, you were not truthful with me. You never disclosed this disability, and now you are, and so I feel that you've betrayed my trust. No, you never have to disclose your disability unless you're seeking reasonable accommodation, and the law says an employer cannot retaliate against you. So I'm going to contradict myself here because I say you never have to disclose disability, right? Excuse me. There is a difference between disclosure, which is voluntarily sharing information about my disability, and then there's self-identification. And this is an invitation from an employer to voluntarily self-identify. Now, why would anybody do that? Well, there are a couple of reasons. I mentioned before that under Section 503 of the Rehab Act, we're working toward a 7% aspirational goal of federal contractors. It would be advantageous for me to self-identify my disability because it might give me preferential hiring. Same would be true if there's an affirmative action program in place. Let's say that my business has an affirmative action program that gives preferential hiring to veterans with disabilities. Then it might be to my advantage to self-identify. So there is a difference between disclosure and self-identification. Now, employers have an obligation, if they ask for self-identification, that it be done anonymously, and that information is kept separate in an anonymous fashion for reporting purposes, say maybe to OFCCP. So why would somebody want to disclose disability? Well, maybe somebody has an obvious disability and they want to address any concerns that the employer has. Maybe you need an accommodation to participate in the interview or a job. Maybe disclosure would offer you, as I said before, a competitive advantage. Maybe bringing your whole self to work is important to you. I have a very dear friend of mine who is autistic, and she identifies as, I am an autistic. She is not a person with autism. In fact, she will say to me, your with is my problem. She is a disability positive, identity first type of individual, and she wants to bring her whole self to work, and that's why she would choose to disclose her disability. As I said before, you know what we do in finding people jobs, job coaches, employment professionals, we have to acknowledge at the beginning, what we do is kind of weird, right? How many people show up with somebody else for a job interview? So early disclosure allows for an understanding of why that job coach or that employment specialist is there. So job disclosure focuses on needs. It provides suggestions for reasonable accommodation, because who's the expert, right? Certainly not the employer. The person with a disability is the expert on how disability impacts their life and what sort of accommodation might need to be put in place. Disclosure focuses on specifics and isn't general. It avoids medical terminology. It avoids it avoids using language that could be a red flag for an employer. You never have to use that label of, I have, you know, mental health diagnosis or whatever. I'm going to be specific in, I have disability X and it is affecting my ability to do the job. That's why I need an accommodation. As I mentioned, it avoids medical terms. You know, if you say mental illness to an employer, every red flag goes up, right? This potential employee is an axe murderer, or, you know, is somehow dangerous, or might be a threat to my business, which is simply not true. So we want to avoid those labels and speak specifically to my disability and how it impacts me. We're going to discuss work barriers, not diagnoses. And it focuses on the here and now. And most importantly, good disclosure is positive. I may have pattern dystrophy, for instance, but I use a screen reader and I know that I am competent and trained to do this job. And that's why I would be a good employee for you. So to who do you disclose to? Well, it depends on timing, when you do it. And it's going to vary. You know, it could be a recruiter, it could be a hiring manager, it could be human resource staff. But the key is to tell only those people who are in a place of power that can get the accommodation that you need. Excuse me. I'm sure many of you have social media. If you're a friend of mine on social media, I will apologize for some of my posts. They're a little out there. But we know that the people we work with or work for, people who we are trying to find work for, have social media as well. So we want to caution them that any pictures or comments or things that you put on social media may result in an inadvertent disclosure. You know, I have a good friend of mine whose first husband died of neurologic disease, and so she started a scholarship program for students with neurologic disability. And each year, someone would be selected for $5,000. And my role with the foundation was, after a team of people had reviewed and made the final 1 or 2 selections, my friend Melinda would come to me and say, are these kids who we think they are? What do you think I did first? I stalked them on social media, of course. Didn't we all? Don't we all? You know, is this person who we say they are? And you know that if I've done it, employers are doing it as well. So be thoughtful and respectful in what you post. Know that anything you put on there will be found online. And remember, once posted, it's not going away. Just briefly, here are some disclosure tools that can help you, and this will be in the handouts you can download. The 411 on disability disclosure workbook is very good. Advising youth with disabilities on disclosure, tips for service providers from Department of Labor. The Art of Disclosing Your Disability by Richard Pimentel is excellent. And you know, all these sources were used in developing these slides as well. Disclosure decisions to get the job, and then disclosure tools from the Job Accommodation Network. So there's no one specific way to request an accommodation. There's not a standardized form. Now, a business may have a form that they prefer to use, but what does the law say? The ADA says that you can request accommodation verbally, written, email. A job coach could make the request for you, or an employee or a family member. You never have to even say, I need an accommodation. You could say, I need help. You know, I'm having difficulty doing my job, and that triggers accommodation request. So what is the responsibility of an employer if you're requesting accommodation? First, they need to recognize that an accommodation request has been made. You know, and again, since there's no specific language, they need to be attuned to what was said to them or what was asked. Employers are responsible for engaging in what's called the interactive process with an employee. So what is the interactive process? Well, basically it's it's a conversation. It is to sit down with that employee, say, I hear that you need some help doing your job. Let's talk about what you need, and let's talk about how you can get it. And so this is a negotiation that is in good faith. So this is where we see a lot of ADA lawsuits in Title I, is because that employer failed to engage in the interactive process or failed to negotiate in good faith. Employers have a responsibility to confirm the existence of a disability. As I said before, they can ask for that narrowly tailored medical information to confirm the existence of the disability. They have to determine if the need for accommodation is an essential job function, which we've already talked about, or a marginal function. They have an obligation to investigate solutions, implement, and document. So simply asking for an accommodation doesn't mean that you get that accommodation, all right? At the end of the day, the law says whatever accommodation is put in place is the selection and responsibility of the employer. Now, going back to my previous statement, who's the best expert on what that is? Well, the best expert is the person with a disability, and so that should come out in that interactive process. Employers also aren't required to honor every request. If it creates an undue hardship for the business, or if it changes the essential functions of the job to the point where the job no longer looks like what it is supposed to be, then an employer would not have to make that accommodation. If it's extensive, if it's too costly, as I mentioned, if it fundamentally changes the function of the job, they don't have to do it. Now, thinking of in terms of being too costly. Courts and the EEOC take a very hard look at all of the resources at a business. So there was a very famous case a few years ago, Searles versus Johns Hopkins Healthcare. Lauren Searles was somebody who was deaf, went through nursing school, graduated with honors. She had an interpreter with her all through school. She gets a job at Johns Hopkins, and she says, well, I still need an interpreter. And Johns Hopkins says, no, the cost, your entry level salary, this was a few years ago, was like $60,000 a year. And the cost of an interpreter is $120,000 a year. This is an undue hardship for us. It is too costly. In looking at this situation, the courts looked at the entire resources of Johns Hopkins Healthcare, which was like $2.1 billion. It was not going to break the bank for Johns Hopkins to pay for that interpreter. Finally, an employer doesn't have to make an accommodation if it's dangerous or if it's illegal. Again, I've mentioned before, granting an accommodation doesn't eliminate the essential functions, nor can it reduce the performance standards of the job. So if I'm an employer, I work for Whaley Widgets, I'm the owner of Whaley Widgets, I have an employee that the performance standard is for them to complete 20 widgets a day. And they say, I'm having trouble, I'm not getting my 20 widgets, I need an accommodation. I don't have to reduce that performance standard and say, okay, just do 17 widgets a day, right? No, what I have to do is to come up with an accommodation that allows that employee who has a disability to complete their 20 widgets a day. So documentation usually becomes a real issue, and I want to spend a little more time on it. Because we live in a very litigious society, right? So an employer does have the right for documentation. It has to be job related and consistent with the business necessity. You can't ask for every bit of documentation. That documentation has to be kept confidential in a separate place. It cannot go into somebody's personnel file, right? It has to be in some sort of encrypted file somewhere else that is very limited to who has access to it. So disability inquiry, because this becomes a very interesting thing for employers, and you as an employment professional or somebody who helps somebody find work needs to understand when potential discrimination has taken place. So what is disability inquiry? It's a question or a series of questions that will solicit information about somebody's disability. We know that there are three phases of the employment process. So there's pre-employment, before an offer of employment is made. There is pre-employment post-offer. So after an offer of employment is made, but before somebody begins work. And then there is employment. So these are the three phases of the employment process. Let's take a look at pre-employment, pre-offer. An employer is not allowed any sort of disability inquiry in pre-employment, pre-offer. They just can't ask about somebody's disability. Back when I did supported employment, I can't tell you how many times an employer would pull me aside and confidentially say, what's wrong with him, right? First of all, it's against the law. This is pre-employment, pre-offer. You cannot ask about somebody's disability. And furthermore, there's nothing wrong with this person at all. It made for some very interesting conversations. So you can't ask about disability in pre-employment, pre-offer. Pre-employment, post-offer, disability inquiries are allowed only if the inquiry is made to all the candidates for the job. So let's say, for instance, a prerequisite for getting a job might include having a drug test or having a medical examination. As long as all candidates in that particular job category are subjected to that, then it would be okay. But if you're singling out somebody with a disability, then that's a discriminatory act. Finally, you have employment, and disability inquiry can only be made if it's job related and if it is of a business necessity. So, I have an employee, one of my employees, that has never disclosed disability to me. So I cannot ask about her disability, but we did have a situation where she simply was not completing her work. Now I can go to her and say, I know you're having some difficulty here. Is there something I can help you with? And then she can choose to self-disclose or not. And if she does, then we can talk about it. But if she chooses not to, then clearly we can't continue with that conversation. So what can employers ask? They can ask how you're doing. They can ask about a non-disability related impairment. Hey, how'd you break your leg, right? They can ask whether someone can perform the essential functions of the job and how they would do that. Employers can ask if someone has been drinking alcohol. Now, they can ask about illegal drug use as well. They can ask general questions, but not specific about pregnancy, and that leads into an entirely different set of laws that we won't discuss today. And they can ask about emergency contact information. So just briefly, this issue of drugs and alcohol, because there are situations where you may have protection under the ADA. Say that say that I'm in a medically assisted treatment program. I am under the care of a doctor. Say I'm taking Suboxone. Then I would have protection because I'm actively in treatment under the ADA. But if I am illegally using drugs, then I do not have protection under the ADA. If I am drunk at work, drinking alcohol, then I may not have protection. If I am in an alcohol treatment program, then I may have protection. And again, this is an entire 2 hours of training we're not going to go into, but let's say that I'm in a treatment program and I fall off the wagon, then I may or may not have protections based upon the agreements I made with my employer. Just a brief word so you are aware about aligned job descriptions. That we want to make sure that job descriptions include inclusionary language and not exclusionary. So, here's some examples. Exclusionary language would be stand or sit. Well, if I'm a wheelchair user, I'm not standing, right? But an ADA aligned language would say stationary position. So do I really need to stand to perform the essential functions of the job, or can I do them in a stationary position? Walk would be exclusionary, to move, to traverse, to travel. Probably one of the greatest areas of concern down at the bottom here, we see lift or carry. You don't necessarily, depending on the job, that may not be an essential function, right? To lift and carry. But to move, to position, to transport, to place may be or are aligned ADA language, and we should be aware of those. So what can't an employer ask in disability inquiry? They can't ask whether a person has or has had a disability. They cannot, during disability inquiry, ask for medical documentation of a condition unless there's a disclosure of disability. They can't ask about genetic information. So part of the ADAAA included protections of genetic information. And so we see that there are protections both under ADA as well as under GINA, the Genetic Information Act. You can't ask about somebody's prior worker comp history. Have you ever filed a worker comp claim? You can't do that. You cannot ask about past prescription medication issues. So here's an interesting thing in our current environment or our recent environment is the whole issue of opioids. So we need to draw a distinction between a misuse of opioids and legal use of opioids. I have a friend who has tremendous ongoing pain, and he uses his opioids responsibly, right? He doesn't abuse that. So using that medication wisely is okay. So an employer couldn't ask him about his use of medication. It might trigger some sort of inadvertent disclosure that didn't need to be made. So I want to spend just a couple of minutes talking about the current environment and ADA and COVID-19, because it has resulted in some very interesting situations. We are seeing at Southeast ADA Center, we're providing a lot of guidance regarding face mask policies, and especially face mask policies in employment. As a matter of fact, on our website, ADA Southeast, there you will find information for Title II and Title III, which are, again, state and local government and shops, goods and services, places of public accommodation. You will see guidance on face mask policies there. So we're seeing a lot of people saying they can't wear face mask policies, and what sort of accommodations might be in place for them. And we also are seeing a lot of concern about disability disclosure as well, because as I said, many people go through their entire life, right, and have never had to disclose disability. So now in the current COVID environment, let's say I have some underlying health condition that would put me at greater risk of COVID. So now I'm forced with the decision, do I disclose my disability or do I not? And what are what would happen if I do? Okay. We're seeing a lot of questions about reasonable accommodation, again, around face masks, a lot about telework or work from home, and where employers are saying, no, you need to return to work. Somebody says I'm at high risk and I have shown you I can complete my essential functions from my home office. So those are some of the things that we are seeing in the current environment. And again, it's an evolving situation. Each week I get a report from my technical staff that is specific to how many COVID calls we took under Title I, Title II, Title III, and what percentage of our technical assistance is devoted to that. And right now it's about 23-24%. So it is a good chunk of callers have these concerns. So let's kind of wrap this up a little bit, because remember I mentioned the guy with the hat at the beginning. And who is that guy? And so I like to talk about Justin Dart. I was doing a training a year ago last spring in Pompano Beach, Florida. And when I go down, I usually like to take some of my boss's books down, right? And ask questions of the audience and give them away. So I asked the question, that slide I had showed you before, who was the guy in the cowboy hat? Not 200, there were 200 people in the room, not one of them could identify Justin Dart. Why is Justin Dart important? Justin Dart is the greatest hero of the disability rights movement. He is the father of the ADA. He was a man who was born of privilege, actually. His mother was the heir to the Walgreens drug fortune. His father was the president of Rexall. He went to school at University of Texas. They denied him a teaching license because of his physical disability. So Dart went on to become the president of Tupperware in Japan, where he met his wife, Yoshiko. The executives of Tupperware in the US saw that what Dart was doing is he was hiring people, women and people with disabilities into executive positions in Japan, and the executive said, stop promoting your women to executive positions and stop this disability campaign. So what did Dart do? He quit. Hit the wrong button there, I'm sorry. So he quit, he returns to the US. President Reagan in 1981 asks him to become the vice chair of the National Council on Disability. So Dart and Yoshiko begin a US listening tour, going to every state and collecting stories from people with disabilities about discrimination that they had faced. So, you know, it's hard in 2020, right, to imagine a world without curb cuts, a world without ramps, a world where simply having a disability would result in you not being hired. So Yoshiko and Justin Dart go on this listening tour. These stories become the foundation of the Americans with Disabilities Act. You know, no matter anything I say, if we could hold that before we start it, no matter anything I say could never be as powerful as Justin Dart's farewell message. So let's take a minute and listen to it.
Dearly beloved, listen to the heart of this old soldier. As with all of us, the time comes when body and mind are battered and weary. But I do not go quietly into the night. I do not give up struggling to be a responsible contributor to the sacred continuum of human life. I do not give up struggling to overcome my weakness, to conform my life and that part of my life called death to the great values of the human's dream. Death is not a tragedy. It is not an evil from which we must escape. Death is as natural as birth. Like childbirth, death is often a time of fear and pain, but also of profound beauty, of celebration of the mystery and majesty which is life pushing its horizons toward oneness with the truth of Mother Universe. The days of dying carry a special responsibility. There is a great potential to communicate values in a uniquely powerful way. The person who dies demonstrating for civil rights. Let my final actions thunder of love, solidarity, protest, of empowerment. I adamantly protest the richest culture in the history of the world, a culture which has the obvious potential to carry a golden age of science and democracy dedicated to maximizing the quality of life of every person, but which still squanders the majority of its human and physical capital on modern versions of primitive symbols of power and prestige. I adamantly protest the richest culture in the history of the world, which still incarcerates millions of humans with and without disabilities in barbaric institutions, back rooms, and worse, windowless cells of oppressive perceptions. for the lack of the most elementary empowerment supports. I call for solidarity among all who love justice, all who love life, to create a revolution that will empower every single human being to govern his or her life, to govern the society, and to be fully productive of life quality for self and for all. I do so love all the patriots of this and every nation who have fought and sacrificed to bring us to the threshold of this beautiful human dream. I do so love America, the beautiful, and our wild, creative, beautiful people. I do so love you, my beautiful colleagues in the disability and civil rights movement. My relationship with Yoshiko Dart includes, but also transcends, love as the word is normally defined. She is my wife, my partner, my mentor, my leader, and my inspiration to believe that the human dream can live. She is the greatest human being I have ever known. Yoshiko, beloved colleagues, I am the luckiest man in the world to have been associated with you. Thanks to you, I die free. Thanks to you, I die in the joy of struggle. Thanks to you, I die in the beautiful belief that the revolution of empowerment will go on. I love you so much. I'm with you always. Lead on, lead on. Let up.
All right. Well, thank you all for allowing me to be with you today. Hopefully the information has been helpful. If you have any questions about the ADA, you can call 1-800-949-4232. You will be put in touch with the ADA Center for your area. Southeast ADA is one of 10 centers that make up the ADA National Network. Or you can call our office, 404-541-9001, or our project email is adasoutheast@law.syr.edu. Oops. Uh-oh. There we go. I hit the wrong button. I apologize. There's my contact information. My email is bawhaley@law.syr.edu. So again, thank you all so much.
Thanks, Barry. We're now going to turn to questions. If you do have a question, please type it into the question section in the control panel. And I do have a couple for you.
Okay.
So the first question that is, with all the exemptions in the ADA, do you think we'll ever have full equality for people with disabilities?
You know, that's very difficult to say.
Mm-hmm.
You know, some of those exemptions were put in place as compromises to have the law put in place in 1990. I can't imagine a world today if we had failed in 1990 to enact the ADA, keeping in mind that in 1988, 2 years before, there was another version of the ADA that reached the floor for vote, and we failed to pass that legislation. So you know, that's kind of a loaded question, and I don't have a good answer for it. I can tell you that we have come so far in 30 years in regard to accessibility, and again, as I said a few minutes ago, I can't imagine a world without curb cuts, or that where there were no employment protections or ramps or accessible parking.
Thank you. Yeah, that was a tough question. Poignant though. There was a question about the PowerPoint. Yes, the PowerPoint is available for download in the handout section of your control panel. You should be able to see handouts on the right-hand side. You can click and download those. So another question is related to the ADA and specific disabilities such as attention deficit disorder and fetal alcohol syndrome. How does the ADA apply to these diagnoses?
Well, those are both diagnoses that may impact one or more major life areas. And under the ADA, you would have civil rights protection in regard to employment, in regard to state and local government services, in regard to goods and services under commercial businesses. So yes, definitely you have protection.
Great. This question gets at the drug testing. What if an employee is subject to drug testing under a state law? What are the implications related to that?
So long as everybody in that job classification is subject to those state laws, then yeah, there is no violation of the ADA. Now, if you are singling out certain employees because of disability, then you may be engaged in a discriminatory practice.
Okay, thank you. I think this was sort of answered, but maybe you can elaborate. If an employer is in violation of the ADA, what would you recommend be the primary enforcement mechanism?
Okay, so a couple of things, just to kind of back up for a second. Maybe it's pretty clear that your rights have been violated. Maybe, however, it's not so clear because things can be kind of vague. The first step that I would recommend is to call that 800 number, 800-949-4232, depending on where you live, and you folks in New Jersey would be served out of the Northeast ADA Center at Cornell University. And so if you called that 800 number, you would be put in touch with one of their technical experts, and those technical experts can talk through what's going on. And if they believe if they believe that your rights may have been violated, they will provide you with information on next steps. So if it is an employment violation, it's going to go to the EEOC, the Equal Employment Opportunity Commission, and if EEOC believes that, and the EEOC does not take every case, unfortunately, but if they feel that rights have been violated, and if they believe that your rights have been violated, then they will contact the employer. They will first engage or try to engage in mediation, which is my background, as opposed to going to litigation. If they could not reach an equitable settlement in mediation, then it would move on to the courts.
Okay. If in that this question is similarly related, if it does get to litigation point and you're looking, I don't know if you'll be able to answer this, what type of questions should you ask a potential lawyer in order for them to defend or obtain accommodations? I don't know if this is necessarily about asking the attorney or what information you need to be prepared to give to the attorney.
Yeah, I'm not really sure what you're asking here, but let me kind of take a stab at it here. So I have experienced discrimination. Let's say that I was terminated from my job because, well, let's do this. Let's say that I asked for accommodation. There was no interactive process. The employer fired me. What are the next steps? So you need to make sure that if you are facing discrimination, that you document what has happened, and be sure that when you engage with somebody, some sort of legal counsel or the EEOC, that you are clear with dates and events and exactly what happened.
Okay, thank you. So this is a specific question to COVID.
Okay.
If under the ADA COVID guidelines, it states that somebody with underlying conditions cannot do in-person work, and the employer agrees with this, but says that you must use sick time and will not grant remote working accommodations, is this grounds for a complaint to be filed?
Colleen, repeat that one more time, just so I understand.
Yeah, it sounds as though a person has said that they have underlying conditions which would be a risk for COVID, and the employer agrees with this, but says that they will not grant remote working accommodations. Instead, you have to use sick time.
Yeah, so potentially that could be discrimination, but let's step back even before that. I had a conversation with an EEOC lawyer a few weeks ago, and fundamentally, the conversation centered on, is COVID-19 itself, does it qualify in the eyes of the EEOC? Does it qualify as a disability that would allow you protection? Let's say that under ADA. Whether you have had COVID or if you have underlying conditions. And he was very vague, and I'm being very vague as well, because I don't think we know that answer yet, but I can tell you that my questioning of him came after he said, we're not saying that COVID is a disability that would affect a major life area, but then his entire presentation centered on ADA protections as if COVID were a major life area or affected a major life area. So I think it's first of all, we're too soon into this. I mean, we're only several months and we've got a long way to go. Now, specific to the question, you want to do remote work, your employer says no. The employer, if they have acted in good faith, again, at the end of the day, the employer makes the decision. So do you have protection or not? I guess it depends on the circumstances.
Okay.
How's that for being vague?
I know, it's a trick, it's tough.
See, and what you need to understand is the ADA is not absolute law. ADA is based on case law. So, probably what you will hear most often from me or my staff is, well, it depends. It depends on the specific circumstances. Sorry, go ahead, Colleen.
And that's okay. Similarly related to COVID, just some clarification about whether or not an employer can or cannot request medical verification for a request to work from home due to COVID, or no.
Yeah, and again, that's difficult to say because we don't have any clear guidance from EEOC on that subject. I can tell you in a worldwide pandemic, yeah, maybe, but we just don't have that guidance. We don't know for sure if that is okay or not.
Okay, thank you. In terms of reasonable accommodations, how frequently do these plans need to be reassessed?
There is no rule of thumb. I would suggest that, as I said before, what is a good accommodation 2 years ago may or may not be a good accommodation today. So, I think that depends on impact of disability. I think it depends on the nature of the essential functions of the job. I think you have to look at again, it depends. It's taking a look at those individual circumstances to determine, what is a qualifying time frame. There are too many variables to put a rubber stamp on it.
Can you describe a little bit about the intersection between reasonable accommodations and job coaching?
Well, and yeah, I can. First and foremost, as I said earlier, you need to remember that as a job coach, you are a reasonable accommodation. I had a fellow who worked at a branch library in Louisville years ago, and the librarian did not want me to have access to the person who I'd gotten a job for, although he clearly needed some help with that work. He had a pretty good job too. It was pretty cool. And the job was, so there are all these volumes in the library that are not circulating. And his job was to research why they weren't being circulated. Was there a newer volume? Was there a newer edition? Was it just a book that was in disrepair? Was it a number of factors? So anyway, in that circumstance, she said, no, you can't have access to him. And I had to remind her gently that, under the ADA, under Title I, I am a reasonable accommodation. I'm here to help you as the employer, and I'm here to help Bob do his job better. And I don't know if I answered your question because I went off on tangential thinking.
I think that's a great example to help illustrate. So thank you. So this is a question related to moving forward and advocacy related to some of the accommodations that were put in place with COVID. So prior to COVID, this individual is giving an example where her disability causes a great deal of fatigue, and there had been an accommodation to work from home part of the day, and that was denied by the employer. And now that many people are working from home, this accommodation seems to be working for a lot of people. And the fear is that once we get back to normal, that will not be seen as an accommodation, even though it was something that was effective to people with and without disabilities at the current time.
Yeah. So as I mentioned before, when I was talking earlier, it will be interesting. I would be interested to see how we redefine work post-COVID. In what we learned, okay, is that many of us could transition easily to remote work, or could transition to our home office. As a matter of fact, my office in Atlanta, we're never going back there. I have my staff inventorying furniture, supplies, equipment, with the belief is we're just going to continue remote work because we did it so well. So, I don't have a crystal ball to say what the future will look like. I can tell you that among my colleagues, we've had lots of conversations that begin with, well, a plus from this is I never realized whatever I realized is. So I don't know. It's interesting to think about what the future of work will look like. And as an aside to that, Burton Blatt Institute just got a RRTC grant to study employment policy, and several of their studies will focus on what work looks like post-COVID. Be interesting to see.
Great, thanks. Yeah, it will be. Thanks for reiterating. So, who typically pays for ADA enforcement litigation? Is the burden on the person litigating?
Well, it depends on the court and how the litigation is filed. Whether the EEOC is representing the interest of an employee who has been discriminated against, or, as I said, EEOC doesn't take every case, right? So if you are, if you're bringing suit against your employer, then there's going to be some cost incurred, and then some cost incurred may be ameliorated by the settlement.
Great. I think you covered this, but I think some clarification may be needed. If you do present a medical note, does the employer have to oblige the accommodation in the note, or is it at the sole discretion of the employer?
At the end of the day, the employer the employer makes the final decision of what accommodation is put in place. So this gets into kind of a vague area. As I said before, who is the expert on how disability has impacted me? Well, that would be the employee. But in that interactive process, the employee says, I want to try accommodation X, and the employer says, well, accommodation Y would cost less. Let's try that first. So that you may be bound by that. Now, are employers mind readers, or can they look into the future? No, of course not. So, sometimes an accommodation works. Sometimes the accommodation doesn't work, and then you have to look at some other means of accommodation. So the interactive process should be a very fluid one. That we should look at a variety of resources and then put in place what's best for everybody. But the simple answer is the employer is the one responsible for what accommodation they grant.
Great, thank you so much. So the other questions I see are really more thank yous for a wonderful presentation that was very informative. So thank you, Barry. And we appreciate your willingness to do this virtually. We know how hard it is sometimes to do a virtual presentation, so we appreciate how you were able to engage. So do you have any last minute statements before we close?
Well, just my last minute statement is thank you again for having me. I'm so sorry we could not do this in person. I was really looking forward to it. Hopefully we'll have the chance to do that in the future if you will invite me back. And then leave you with, as Justin Dart would say, lead on, because you folks I'm sure many of you are the next generation of the disability rights movement, and we need you. So thank you all so much.
Thank you so much. And I can't think of a better way to end with lead on. So thank you, Barry, for this wonderful presentation. I'd like to make sure that all the attendees complete the evaluation that will appear at the end of your screen in a moment. Certificates of attendance, again, will be emailed next week to those attendees that were logged on for the entire session and completed the evaluation. Thank you all for joining us for this session of the Developmental Disabilities Lecture Series. We wish you and your family well, and we hope that you will be able to join us at future sessions. If you'd like to register for these future sessions, they are all available on the Boggs Center website. I'd also like to point out that this is the upcoming election is soon, and it's very important that everybody get out to vote. We also have a new resource on voting in the general election that's available on our website. Stay well. Thank you for completing your evaluation. Please stay on your screen, and when prompted, click close if needed for the evaluation to pop up. Thank you all. Thank you, Barry.
Thanks, everybody.